Thanks, Jennifer. Your Excellencies, distinguished guests, ladies and gentlemen, good morning. Legal Aid South Africa is an organization that is mandated by the Constitution to protect the rights of the poor and vulnerable, and thus has the responsibility of ensuring that indigenous people have access to quality justice, and also that the public has access to the services with ease, and such services have got impact in the community. To ensure that we're able to deliver on this, having been informed by research and reviews, we then implemented what we call mixed model delivery system, which comprises justice centers, judicial cooperation agreements, agency agreements, call center, or called legal aid advice line, impaired litigation unit, and pro bono models. I'll now set out briefly the key features of these models as how we have implemented the same in South Africa. Looking at the justice centers, which are based or structured according to the traditional law firm. They are strategically located throughout the whole country with a geographical area identified to cover certain courts, criminal courts in this particular case. And the distances where they are longer, they are shortened by the usage of the branch offices, which we call satellite offices. Currently, we have 64 justice centers and 64 satellite offices. And each justice center renders a range of services. And the typical justice center will have the criminal section, the civil section, and the advice section, which is generally covered by the paralegals with the support of the qualified lawyers within the justice center. Justice centers that are located around the areas where there is high court or a labor court, they will have, in addition to the set up sectors, the high court unit as well as the labor unit. Justice centers have been able to assist us in reducing the cost of analyzing a case comparing to judicial, with the staffing of about, as the end of last financial year, 280 legal practitioners, legal staff including paralegals, 580 support staff. Justice centers, I would say, are our main delivery model that delivers 90% above of our matters. And the last financial year, they delivered about 94% of the total number of matters in organization and finalized 96% of our matters. This model has assisted us to also implement a practitioner per court model, which enables us to cover the court as per each courtroom, allocating practitioners to be able to cover all cases that emanate, that come from individual courts. In that regard, we are able to deliver at the highest level without compromising a principle around the double booking. And also we ensure that there are no cases that fall through the cracks in the process of implementing the same. This model also has assisted us in ensuring that we are able to deal with reputational issues, as we are able to deal with such issues as urgently as possible because of the control we have of the system as an internal model. We also implement the quality assurance manual with ease because of the fact that we have in-house practitioners who we can manage and properly supervise in terms of the issues of quality. The stakeholders like this type of a model because it enables them to interact with us with ease. Also, when they have issues that they raise with us, we are able to address the issues quickly because of the fact that we can manage the internal processes in addressing such issues. Our physical presence in the courts, as per the model I indicated earlier, enables us to assure ourselves that we are able to cover the courts quite efficiently. If one briefly looks at the judicial model, it is a model where private practitioners get accredited with us to be able to receive instructions and represent clients on our behalf. Accreditation entails an application by a practitioner to do such work. Among other requirements, the practitioner is going to comply with that he is going to be in good standing with the law society or the regulatory body. Also be in good standing with the receiver revenue. He must be paying tax. Practitioners are accredited at different levels in terms of the field of experience as well as the field of specialization. And this model enables us to address special gaps around conflict of interest situations, capacity issues where our practitioners might be on training and issues. It also assists us in terms of looking at specialization, where we're looking at specializing. In the last financial year, this model only used about 4% of our budget, with the benefit of about 16,000 matters received from the same. I must mention that also in this model, clients do not have a choice of a practitioner unless in exceptional circumstances. If I move to a cooperation partners model, this is a model where the organization enters into an agreement with an NGO or a university law clinic by way of funding such a partner in the provision of the services. This model has assistance mainly on issues of increasing access to civil legal aid, as they specialize mainly on children's matters as well as on land matters. As at the end of last financial year, we had about 9 partners, and they delivered around about 546 new matters and finalized 4,867 matters. The benefit to us is the increase of civil legal as I've indicated, but the university law clinics also benefit out of this in terms of providing the students with the practical legal training. We also get the benefit of recruiting the relevant staff from candidates who can then groom to a senior level of practitioners who have interest in working with the communities and understanding how to work with the poor. If I look at the HS agreements model, this entails a situation where we enter into an agreement with a private practitioner who will cover a specific court, covering all cases that emanate from the particular court on a daily basis on a monthly fee, which is based on the number of cases to be finalized by the practitioner a month. And that fee is calculated on the basis of 75% of the cost of duty care. And also this is one model which comes cheaper than the duty care model. As at the end of last financial year, we had 6 agency partners that assisted us as another model of service delivery. The rationale behind this agency agreement model was to ensure that those courts that were remotely stationed or located were also covered, because from our position they couldn't be covered from justice centers or by the settlement office, and they were unattractive to the judicial practitioners, so it was basically uneconomical to cover the same. So this came as a solution to the issue. We also maintain quality standards within the same model by ensuring that we incorporate the quality issues in the agreement we signed with this model. The advice line or the call center, we identified a problem that some of the clients, as it was indicated yesterday, do not necessarily need a litigation, they need just general advice, and they'll be able to resolve their matters. But over and above that, we found, based on the research, that some of the clients were unable to reach our offices or service centers because of financial problems. Therefore, in 2010, we identified this model as a model to close this particular gap, where clients can call from anywhere seeking for an advice. And I must indicate that this model has assisted us in terms of extending linkages and access to different places. People can call us from the correctional centers or from the holding cells, who could be the police stations, in terms of seeking the advice they are requiring. If one looks at the productivity around the general advice, in the last financial year, this call center gave us about 61,275 clients were consulted with and given advice, and which is quite a high number looking at the access. In patent litigation services model is a standalone unit within the organization. it provides for a specific function in terms of litigated matters that are intended specifically for the enforcement and interpretation of the rights of the larger group of people, and thus impacting positively to the society and the community. In this particular case, we also have these cases identified by NGOs or justice centers, and we prefer these matters to Legal Services Center for their litigation. Pro bono, which is the last model, relates to the rendering of services by the private practitioners in meeting the requirements of their regulatory bodies. But in this particular case, we are creating private practitioners to receive matters from us. So the benefit of getting involved with this model in our case is to ensure that we are able to extend access to justice without any budgetary requirements. I think my time is up. Thank you, ladies and gentlemen, for this.